My drone was 200 feet above my desert lot when its camera caught the evidence the HOA had spent 9 days denying: 14 RVs, 3 gravel pads, a cut gate chain, and Denise Kavanaugh pointing a contractor toward a fresh utility trench. From the ground, the parcel looked almost empty behind a ridge of creosote and pale sand. From the air, it looked like a planned campground. I saved the original flight file, screen-recorded the live map, and kept the controller untouched while the drone completed its grid. 10 minutes later, Denise's white SUV raced through my gate and stopped hard enough to throw dust across my boots. "Delete that footage. You're recording HOA residents without permission." I asked her one question: which recorded document gave the association the right to place those residents on my land? She answered by holding up a color subdivision map. Then my drone camera tilted down and captured the county survey monument beside her tire, more than 600 feet outside the HOA boundary shown on the recorded plat I owned. The map in her hand wasn't the real problem. The fresh trench beneath it was. And by sunset, one contractor would admit exactly who ordered it dug. His name was Marcus Bell. He shut down his skid steer when I approached, leaving the bucket suspended above a mound of loose caliche. I photographed the machine, the work area, and the orange flags marking a route toward the dry wash. Diesel hung in the air while generators thumped behind the RVs. Marcus looked from my driver's license to the name on the drone case. "Mrs. Kavanaugh told us you signed the site license. She said the original was with the management company." I told him I had never signed a license and asked him not to destroy or move any paperwork. I did not order him off the property or touch his equipment. I wanted a clean record of what had happened before anyone had time to rearrange it. Marcus lowered the bucket, switched off the ignition, and photographed his work order. Denise remained beside her SUV, speaking into her phone. The map she had shown me was glossy and marked "Future Community Area" across the western desert. It carried no recorder's stamp, legal description, parcel number, or owner's signature. I photographed both sides. Before leaving, I walked the gate line with my phone recording continuously. The steel posts were undamaged, but the hardened chain had been cut in one place and dropped behind a creosote bush. Beyond them, electrical cords disappeared beneath rubber covers, and white campsite numbers had been staked into ground I had never offered to anyone. At home, I copied the drone files onto 2 drives, exported the flight log, and wrote down the time of every conversation while it was still clear. Frame by frame, the trench became more troubling. It did not stop at the temporary power box. It continued southwest beyond the last RV, following the natural slope toward the dry wash. Whatever Denise had authorized, it was larger than a few vehicles parked without permission. The question was no longer whether the HOA had entered my land. My drone had answered that. The question was what they were trying to bury before I arrived. That question kept me awake long after the flight files finished copying. I was 46, and most of my work involved restoring land after utility projects, road construction, and erosion. I understood how quickly one careless trench could redirect water across desert ground. I also understood that knowing the land did not give me the authority to decide a disputed boundary by myself. For that, I would need records and someone qualified to place them on the ground. I had bought the 22 acres 9 years earlier from Eleanor Voss, a retired botanist who called the parcel Red Mesa. She had refused every offer from the developer that built Sandstone Vista beside it. When she sold the land to me, her deed transferred Red Mesa as a separate parcel with its own legal description and access from the county road. Nothing in my closing packet mentioned HOA membership, shared amenities, or community use. Eleanor had spent decades cataloging the plants that survived there, and I had promised that any business I built would preserve the wash and the oldest creosote stands around the ridge. The property looked empty to anyone driving past at highway speed. A low ridge hid most of it behind creosote, brittlebush, and pale volcanic gravel. My steel gate stood on the north side. A narrow track ran southwest to a small equipment shelter, then curved toward the dry wash. I stored irrigation pipe and restoration tools there, and I had spent 2 years preparing a level area for a native plant nursery. The first seedlings were supposed to arrive that fall. Sandstone Vista had been smaller when I purchased Red Mesa. Since then, 2 new streets had pushed west, bringing tiled roofs within sight of my ridge. The HOA was also renovating its clubhouse and pool complex. Trucks moved through the subdivision every weekday, and temporary fencing surrounded the project. None of that concerned me until the board apparently decided my vacant-looking land could solve one of its construction problems. The morning after the drone flight, a certified letter arrived from Denise. It described Red Mesa as a temporary community overflow area shown on the subdivision's original development plan. According to her, the RVs housed contractors and other approved occupants connected to the renovation. She demanded that I stop interfering with access and claimed the HOA was finalizing paperwork that confirmed its rights. There was no deed, easement, license, or recording number attached. The only enclosure was a reduced copy of the glossy map Denise had held beside her SUV. I returned to Red Mesa that afternoon with my phone recording and a neighbor from outside Sandstone Vista as a witness. I stayed on the entrance track and did not approach anyone's door. One of the RV occupants, a traveling electrician named Aaron Pike, came over while I photographed the cut chain. "We paid the association, not some private owner," he said. "They gave us numbered spaces and said utilities were included." Aaron looked more confused than hostile when I explained that I owned the parcel. He opened an email on his phone and showed me a receipt from Sandstone Vista for a $650 temporary site fee. The attached parking instructions matched the white numbers driven into my soil. I photographed the receipt with his permission, but left his personal information out of the frame. 14 spaces at $650 meant the HOA had collected $9,100 for land it had not proved it could use. That made the occupants witnesses as much as intruders. They had been given written assurances, assigned locations, and directed through a gate the association did not own. Back at home, I laid my closing survey, deed exhibit, and Denise's development map across the kitchen table. Her map showed a wide shaded area labeled Future Community Area, but its western line ignored the parcel boundary printed on my deed exhibit. A dirt road appeared in 2 different places. Even the dry wash bent differently. I aligned the maps using the county road and the subdivision entrance. The result left Denise's claimed boundary hundreds of feet west of the line in my closing documents. I could see the discrepancy, but I could not responsibly declare the exact distance from paper alone. That required a fresh title search and a certified survey. Until those were complete, the number that mattered was not 14 RVs or $9,100. It was the distance between the boundary Denise claimed and the boundary the recorded documents might actually establish. The next morning, I called Lena Ortiz, a property attorney I had worked with on restoration contracts. Lena was 42, careful with language, and unimpressed by dramatic maps. She reviewed the drone footage, Denise's letter, my deed, and the receipt from Aaron Pike before offering any conclusion. "Your deed is strong evidence of ownership," she said, "but we still need the recorded chain and a survey that ties the description to monuments on the ground." That was exactly the restraint I wanted. Lena ordered a current title report and copies of every recorded instrument affecting Red Mesa and the western side of Sandstone Vista. She also contacted Owen Price, a 58-year-old licensed surveyor who had spent 3 decades working desert parcels where fences, washes, and old development drawings rarely agreed. Owen began with the legal description in my deed, not the line on either color map. 2 days later, I met him at the north gate. He carried a field controller, measuring equipment, copies of the recorded plat, and the patient expression of someone accustomed to landowners wanting immediate answers. We started at a brass monument beside the county road. From there, Owen followed the deed calls toward a second monument partly buried near the Sandstone Vista entrance. The points matched the recorded plat within normal survey tolerances. He then worked west across the pale gravel while I stayed behind his line of sight and kept the RV occupants away from his equipment. By late afternoon, orange stakes marked the western HOA boundary. They stood nowhere near the RVs. The closest campsite was 612 feet west of that line, entirely inside Red Mesa. Even Denise's white SUV had been parked more than 600 feet beyond the association's recorded edge when she held up her map. Owen photographed every recovered monument, logged the equipment setup, and gave Lena copies of his raw measurements and field notes. Nothing depended on a single painted stake that someone could pull from the ground after we left, or quietly move after dark without witnesses. Owen was clear about what his work did and did not establish. The survey located the deed descriptions and monuments. It supported my boundary position, but it did not by itself decide whether some separate easement or license existed. That question belonged in the recorded documents Lena was collecting. The title report arrived the following day. Red Mesa's chain ran cleanly from Eleanor Voss to me. No deed conveyed any portion to Sandstone Vista. No recorded easement granted RV parking, utility installation, construction access, or community overflow use. There was no reservation, license, or agreement matching the shaded area on Denise's development map. Lena found one more discrepancy in the county permit archive. Sandstone Vista had obtained approval for a temporary electrical connection serving its clubhouse renovation, but the site description placed the equipment on a designated staging area inside the subdivision. The approved location was east of the monument. The power box visible in my drone footage was west of it, beside the RV pads on Red Mesa. Marcus confirmed that his crew had begun at the permitted location until Denise redirected them. She told him the internal staging area was needed for material deliveries and that the association controlled the desert parcel. His work order contained the new coordinates but no amended permit and no signed authorization from me. With those pieces in place, Lena sent a formal cease and desist letter to the HOA, its management company, Marcus's employer, and the electrical contractor. It demanded that all excavation and installations stop immediately. It also required them to preserve emails, work orders, invoices, meeting records, permits, payment receipts, and communications concerning Red Mesa. The letter did not demand that 14 occupied RVs disappear without warning. Lena proposed a short, supervised relocation period so the occupants could leave safely while the contractors secured their equipment. That distinction mattered to me. The families inside those vehicles had relied on the same assurances Marcus had. Denise answered through the management company that evening. She repeated that the original developer had designated Red Mesa for community use and added a new claim. Eleanor had supposedly allowed association access before selling the parcel. No date, witness, written agreement, or recorded instrument accompanied the assertion. Denise ended by warning that the HOA would hold me responsible for disrupting its renovation schedule. Lena explained that occasional permission from a former owner would not automatically become a transferable right to build an RV camp. Still, she would examine the claim instead of dismissing it. We preserved Denise's response and asked for every document supporting it. 3 hours after the cease and desist notice was confirmed delivered, my motion alert activated again. I launched the drone from outside the occupied area and watched its camera rise over the ridge. A crew was working under portable lights near the utility trench. The excavator was no longer digging it deeper, it was pushing the loose earth back in. The drone footage showed the crew closing only the section nearest the power box. The farther trench remained open, and the portable lights revealed fresh tire tracks over the survey line. Lena sent the recording to every recipient of the preservation notice before midnight. She did not accuse anyone of destroying evidence. She stated the observable facts, attached the time-stamped images, and demanded confirmation that no additional soil would be moved. Denise answered by changing the audience. The next morning, Sandstone Vista residents received a community alert claiming I had flown a drone dangerously close to occupied RVs, threatened essential workers, and interfered with an authorized emergency project. A homeowner I had never met forwarded the alert to me because she thought the language sounded excessive. I wanted to publish the unedited footage and let people see Denise standing under the drone with her false map. Lena told me to resist that impulse. Public arguments could expose the RV occupants, distort the evidence, and create side disputes that had nothing to do with title. I gave her the original files and said nothing online. At Red Mesa, the pressure continued. The HOA placed temporary plastic barriers along the entrance track and hung signs identifying the area as resident parking. The electrical contractor energized the temporary power box even though its permit described a different site. Extension cords remained connected to several RVs. Each day that equipment operated made the disagreement less theoretical and the risk more immediate. Then the weather turned. Desert rain arrived hard and fast 2 nights later, striking the metal roof of my equipment shelter like thrown gravel. Water rushed off the ridge, found the disturbed trench, and followed it southwest. By dawn, a brown channel had cut through the nursery area I had spent 2 years leveling. Gravel from the RV pads had washed into the native soil, and one bank of the dry wash had collapsed where the trench crossed the slope above it. I did not begin repairs. Moving the soil would have erased the condition I needed to document. Lena arranged for a restoration specialist to inspect the parcel that afternoon. We photographed the erosion from fixed points, measured the channel, marked the contaminated gravel, and recorded the exposed utility material. The specialist prepared an initial report, separating storm effects from damage made worse by the grading and trench alignment. Marcus arrived while we were working. He had removed his company's equipment from the site and instructed his crew not to return. He looked tired rather than defensive. "I asked for the signed license 3 times, he said. Every time, Denise told me it was being processed and that the board had already approved the location. He had preserved the emails, the original work order, the revised coordinates, and photographs taken before his crew began. The first work order placed the temporary staging area inside Sandstone Vista, matching the county permit. A later version redirected the grading west to Red Mesa. Denise's email attached the glossy development map and described the parcel as HOA-controlled land. It did not attach my signature. Marcus would not decide who owned the property, and I did not ask him to. What he could establish was conduct. Who changed the location? What assurances were given? What documents were missing? And when the work occurred? Lena arranged for him to provide the records through his company's attorney, so their source and custody would be clear. Aaron Pike helped with another part of the record. He asked the other occupants to check their payment confirmations. 14 receipts came back, each charging $650 for a numbered temporary site. Together, they confirmed the $9,100 total. Several listed the payment destination as a Sandstone Vista renovation account rather than a separate escrow or land use account. The preservation notice also reached Jonah Reed, the 55-year-old HOA treasurer. Jonah did not send Lena internal records or discuss confidential board advice. He contacted her only to confirm that he had preserved the financial files and retained separate counsel. Before ending the call, he said he had never seen a signed agreement from me and had questions about why the site fees entered the clubhouse budget. His caution told me he was protecting the association, but no longer confusing that duty with protecting Denise from the evidence already preserved. That was the first visible fracture inside the board. Denise had a reason for pushing the project forward. The clubhouse renovation was already delayed. Its internal staging area was crowded with materials, and another assessment would have angered residents. Red Mesa offered space for contractor housing and $9,100 in immediate revenue. The motive did not create a legal right, but it explained why she treated an obsolete concept map as if it were a deed. By the end of the week, the evidence no longer consisted of one angry confrontation and a drone video. We had the deed chain, survey, permit mismatch, post-notice footage, restoration report, contractor records, 14 receipts, and confirmation that relevant financial files still existed. The temporary power box was still active. The RVs were still occupied. Runoff had already reached the dry wash, and Denise had given no date for relocation. Lena spread the records across her conference table, arranged them by date, and opened a new filing binder. The tab on its cover did not say demand letter. It said complaint. Lena filed the complaint the following Monday. It asked the court to declare that Sandstone Vista possessed no right to occupy Red Mesa, stop further entry and construction, require removal of the temporary installations, and award damages for trespass, restoration, and lost use. A separate motion requested temporary relief while those claims were litigated. The HOA received notice and filed an opposition. Its attorney did not rely solely on Denise's glossy map. The response argued that the association had reasonably relied on the original developer's plan, prior informal access, and the expectation that I would sign a temporary license. It also warned that an immediate shutdown could leave 14 households without power and create additional expense for homeowners. That was their strongest argument, and Lena treated it seriously. We were not asking the court to decide the entire ownership case in one emergency session. We were asking it to prevent new work, remove the electrical risk, and require the HOA to relocate occupants it had placed there while the documents were examined through normal process. The contested hearing took place 6 days after filing. Owen's survey, the title report, permit description, storm photographs, and drone footage were submitted with sworn declarations. The HOA presented Denise's development map and evidence that the RV occupants depended on the temporary site. After hearing both sides, the judge prohibited additional excavation and use of the power box. The HOA was given 72 hours to move the RVs to lawful spaces it arranged and paid for. The order preserved everyone's final claims. It did not yet declare who held title or whether any enforceable access right existed. The relocation was quiet. Aaron sent me one photograph of his RV leaving through the north gate. By the third evening, the generators were silent, and the desert held 14 empty rectangles of compressed gravel. Denise responded with a notice to Sandstone Vista homeowners. It blamed an unexpected legal obstruction for relocation, cleanup, and contractor costs, and announced that the board was considering a special assessment. My name appeared twice. The notice did not mention the missing license or the permit for a different location. Residents demanded a meeting. Lena and I attended because the board had described me as the cause of their potential bill. Denise sat at the front of the packed clubhouse, tapping the notice with one polished nail. Mr. Hart created this crisis by withdrawing cooperation after the project began, she said. Lena connected her laptop to the projector. The first image showed 14 RVs spread across Red Mesa. The next showed Denise beside the cut chain. A third displayed the original flight date and coordinates, recorded 11 days before the board's incident chronology claimed work had begun. Then Lena placed the county permit beside Owen's boundary exhibit. The permitted staging site and the occupied parcel were visibly different. We did not present the meeting as a trial or announce that we had already won. Lena explained that the temporary order preserved the property until the recorded rights could be decided. The room's anger did not disappear, but it changed direction. Residents began asking Denise to display the signed license she kept referencing. She did not produce it. Discovery continued for the next 3 months. The HOA produced board minutes, management emails, accounting records, project files, and earlier drafts of the temporary site proposal. 2 directors had asked for proof that Sandstone Vista owned or controlled Red Mesa before any RV fees were collected. Their questions were recorded in the minutes, but omitted from the project summary sent to contractors. An email from Jonah Reed was more direct. He had attached a property search listing me as Red Mesa's owner and asked Denise whether Association Council had approved the plan. Denise replied that the original development map gave the board enough authority to proceed and that a formal license could be obtained afterward. Her answer came 4 days before Marcus received the revised coordinates. The document requests covered every place a signed agreement might reasonably exist: the HOA's files, its management company, prior counsel, the renovation contractor, the payment processor, and Denise's board account. None contained an executed license. There were drafts with blank signature lines, but no version bearing my name or Eleanor's. 2 directors retained independent counsel and stopped supporting Denise's litigation position. Jonah continued preserving the financial records. The $9,100 in RV fees appeared as renovation income and had been used against clubhouse expenses within days of collection. Marcus testified under oath about the location change. He identified Denise's emails, his original and revised work orders, and the repeated promises that signed authorization was coming. He did not offer an opinion on title. He simply described why his company entered Red Mesa and who directed it there. The HOA challenged the drone footage, suggesting its display map could have been altered after the flight. Lena retained a digital evidence examiner who copied the original storage card, verified the file metadata against the controller log, and matched visible landmarks to Owen's survey. The examiner found no editing in the source recordings. By the time discovery closed, the case had become larger than Denise's map, but simpler in one important way. Every independent record pointed in the same direction. The deed identified the owner. The survey located the land. The permit named another site. The drone preserved the occupation. The contractor records showed who ordered it. The financial files explained why. The night before trial, Denise's attorney filed a final exhibit list that still described the concept map as the foundation of the HOA's authority. Lena read it once, closed her laptop, and placed the recorded plat into the front of her trial box. The trial began 4 months after my first drone flight and lasted 2 days. There was no jury, no packed gallery, and no dramatic ruling before lunch. The judge had hundreds of pages to compare, and both sides were allowed to build their cases piece by piece. The HOA's attorney went first. He argued that Sandstone Vista had not entered Red Mesa out of malice. The board had an overcrowded renovation site, workers who needed temporary housing, a development map showing future community use, and a history of occasional access during Eleanor's ownership. Denise, he said, believed those facts created at least temporary authority and reasonably expected a written license to follow. Lena did not call that argument ridiculous. She separated its parts. A need for space was not a property right. An expectation of a future signature was not a present license. Occasional permission, even if proven, was not the same as a recorded easement allowing an HOA to cut a chain, charge site fees, grade 3 pads, energize a power box, and dig toward a dry wash. The first major comparison involved the two maps. Denise's exhibit came from an early development package and labeled a broad desert area, future community area. It contained no legal description, parcel number, owner signature, or recorder's stamp. The recorded plat in Lena's trial box showed Sandstone Vista ending at the monuments Owen had recovered. Red Mesa remained outside it. Owen explained how he began at the brass monument beside the county road, followed the deed calls, verified the second monument, and checked his measurements against the recorded plat. His field notes, equipment logs, and photographs supported each step. The nearest RV pad had stood 612 feet west of the HOA boundary. On cross-examination, the HOA asked whether a survey could prove that no unrecorded agreement ever existed. Owen answered that it could not. His role was to locate the described parcels. That honest limitation helped rather than hurt us, because Lena never presented the survey as the entire case. The title professional supplied the next layer. She traced Red Mesa from Eleanor to me and reviewed every recorded instrument identified in the search. Nothing conveyed ownership to Sandstone Vista or granted it an easement for parking, utilities, construction access, or community overflow. The HOA produced no separate executed license to fill that gap. County records established that the temporary electrical permit named a staging area inside the subdivision. Marcus's original work order matched that site. His revised order moved the work west after Denise emailed him the concept map and assured him that the association controlled Red Mesa. When Marcus testified, he did not exaggerate. He admitted relying on Denise instead of independently verifying title. He also described asking 3 times for the signed license and receiving promises that it was being processed. His photographs showed the untouched ground before grading. His crew logs fixed the dates of the pads and trench. Then Lena played the drone footage. The courtroom monitor showed 14 RV roofs against pale gravel, 3 graded rectangles, electrical cords, the cut gate chain, and Denise directing workers from the center of my parcel. The flight map placed every image west of Owen's boundary. Later clips showed work continuing after the cease and desist notice and soil being pushed into part of the trench under portable lights. I explained why I made 2 copies, preserved the storage card, exported the flight log, and avoided publishing the video. The digital evidence examiner confirmed that the source files matched the controller data and contained no editing. The HOA's challenge to the footage did not survive the originals. The most damaging records were less visual. Board minutes showed two directors asking for ownership verification before Denise authorized the RV plan. Jonah's email attached a search naming me as owner. Denise's reply said the concept map was sufficient to begin, and a license could be obtained afterward. The financial ledger showed $9,100 collected from 14 occupants and applied to clubhouse expenses. Denise testified that she believed the old map reflected the developer's long-term intent and that delay threatened the renovation budget. She denied trying to steal land or hide revenue. I believe she had convinced herself that keeping the project moving justified treating unanswered questions as approvals. That made her decisions understandable. It did not make them authorized. The judge took the matter under advisement. 3 weeks later, the written decision arrived. The decision emphasized that the result did not rest on the drone alone. The footage proved possession and conduct. The deed, plat, title chain, survey, permit, emails, and receipts established why that conduct lacked authority and what harm followed over the months leading to trial itself. It declared that Sandstone Vista held no ownership interest, easement, or enforceable license authorizing its use of Red Mesa. The concept map expressed a preliminary planning idea. It did not transfer property rights. The order permanently barred the HOA, its contractors, and agents from entering or installing improvements without my written permission. The HOA was required to remove the gravel pads, temporary electrical equipment, campsite markers, signs, trench material, and remaining barriers. It also had to correct its internal maps and record notice of the judgment with the property records, so the same claim could not quietly return under a future board. The damage award totaled $43,550. That included $1,850 for the gate and immediate security, $18,400 for gravel removal and soil restoration, $10,600 for drainage and dry wash repair, $7,200 for survey, title, and inspection expenses, and $5,500 for documented nursery delay and lost use. Each amount came from receipts, estimates, or testimony already in the record. The court left a remaining dispute over legal expenses for later resolution. Rather than continue litigating that issue, the parties negotiated an additional $18,000 contribution toward my legal costs. The agreement did not label it punishment or invent a giant windfall. It closed the expense dispute and set deadlines for payment and restoration. The reconstituted board also agreed to refund the $9,100 collected from the RV occupants. That money had never belonged to me, and I did not ask for it. It went back to the people who had paid for spaces the HOA had no right to rent. Within a week, the directors removed Denise as president after reviewing the emails and financial decisions. There was no arrest and no final shouting match. The consequence was institutional. She lost the position that had allowed her assumptions to become instructions. On the morning the judgment became final, I unlocked Red Mesa's temporary replacement chain and waited beside the north gate. A restoration truck turned off the county road, carrying equipment to remove the first gravel pad. The restoration took 6 weeks. Crews began by lifting the gravel instead of pushing it farther into the desert. They removed the 3 pads in measured sections, hauled away the campsite markers and plastic barriers, disconnected the temporary power equipment, and reopened the filled portion of the trench so damaged material could be removed properly. The dry wash repair required slower work. The restoration specialist rebuilt the collapsed bank to its documented contour and stabilized the runoff path without turning it into a concrete channel. Native stone replaced imported gravel. Creosote and brittlebush salvaged from undisturbed areas were replanted around the nursery site, and each repair was photographed from the same fixed points used after the storm. I replaced the temporary chain with a new steel gate assembly, hardened lock, 2 cameras, and signs that identified Red Mesa as private property. The signs were plain. They did not mention Denise, the lawsuit, or the HOA. Their purpose was to prevent another mistake, not preserve an argument. Sandstone Vista recorded notice of the judgment and issued a corrected boundary exhibit. Jonah, serving as interim president, sent the revised map to homeowners, contractors, and the management company. The board adopted a requirement that any future project crossing an existing parcel line receive independent title review before money was collected or work authorized. The 14 RV occupants received their $650 refunds. Aaron sent me a short message confirming his payment had arrived. He apologized for entering my land. I told him the responsibility belonged with the people who assigned the spaces and accepted the fees. We had both trusted documents that appeared official. Only one of us had been given the wrong ones. Denise resigned from the board before the next election. I never spoke with her again. That suited me. The judgment had corrected the claim, the board had corrected its procedures, and the land did not need a final confrontation to become mine again. When the restoration inspector approved the completed work, I brought the first trays of nursery seedlings to the equipment shelter. Their leaves looked impossibly green against the pale gravel. I set them beside the irrigation pipe Eleanor had helped me select years earlier and began rebuilding the level beds the storm had cut through. Near sunset, I launched the drone from the north gate one final time. It climbed over the ridge along the same route as the first flight. The camera showed open desert where 14 white RV roofs had once crowded the frame. The 3 gravel rectangles were gone. The repaired wash followed its natural line, and the new gate cast one narrow shadow across the entrance track. This time, every boundary below it was finally where it belonged. I had once thought the drone captured the truth by itself. It had not. It captured the first visible layer: vehicles, machinery, a cut chain, and a trench the HOA denied. The rest came from restraint, preserved files, recorded deeds, careful measurements, contractor records, financial entries, and people willing to state what they knew. I brought the drone down slowly until its motors softened into silence. When it settled into my hand, Red Mesa was quiet behind me, not empty, not abandoned, and never community overflow. Just 22 acres returned to the work I had planned for them.